I'm Harvey Blankfeld, host of Las Vegas Real Estate Now and principal of the Blankfeld Group at Berkshire Hathaway Home Services of Nevada. We have prepared this video for you so you can better understand the documents we use here in Southern Nevada. And while we don't review every section of the document, we do try and clear up some of the most relevant concerns. We are recording this video in 2023, and if you're watching long after that, there are likely changes that have taken place with this document, and this video may have some parts that are outdated. Also know that we operate in Southern Nevada, and these forms are specific to our market. While you may be able to glean some value from this video, please know that no two markets operate exactly alike. And finally, I need you to know that I'm not an attorney, and none of what I'm saying should be interpreted as legal advice. Okay, let's get started. The Las Vegas Realtors Residential Property Management Agreement. This is a document provided by our local board for us to use when we are making an agreement between a landlord and ourselves to manage their property. It's 14 pages. There's a lot to it, so let's just get right to it. Starting off right up top is the address of the property we're going to be managing. Then here's the date we're entering into the agreement. Here's the names of the homeowners, Mr. and Mrs. Landlord. Our broker is Forrest Barbie. Our company is BHHSNV, Berkshire Hathaway Home Services of Nevada. There's my name. I'm the authorized agent here. And here's my PM license number right down here. The description of the property, this talks about whether or not there's more than one property. We can always add additional properties to this agreement with exhibits. You're going to see in this case we have an exhibit A and then B and C and so forth. If we wanted to add more properties to the existing agreement, we could. Here's the information for our homeowners over here, and here's the information for us over here. And then this employment and acceptance basically talks about the relationship between us and the owner. The owner is employing us as the sole agent of them to manage this property. It's not specifically an employment agreement, although that's the terms within it do identify it as such. The relationship shall be of the principal and an agent. We end up act as an agent on their behalf, and we have the right to make decisions for them relating to the property as a result of this agreement. Page 2, the term, this is for 1 year. This one starts on January 25th of this year, ends on January 31st of next year. This is how we are to be compensated. Now, let me make a quick note before I get into the compensation. This agreement shall renew annually upon its anniversary date for successive periods of 1 year. So every year, unless in writing otherwise, this agreement automatically renews for another year, okay? Our compensation. We're going to be paid the greater of $100 per month or 10% of the rents. And then we're paid, I left this blank intentionally so you can see, you don't really want any blank elements on this contract. You want this to be completed. In our case, it would be 0. We don't charge any money to our landlords if the property is vacant. Other management companies may decide to do that. Our leasing fee is either the greater of $800 or 20% of the first month's rent. And then they'll pay a non-refundable fee each time a new tenant is placed in the subject. It's the same fee every time for us. There may be additional fees for other management companies as well. This is where a management company would put in a setup fee. We don't charge one. Here's the referral commission. Of that $800 here, of this, we are giving $300 of it to whatever agent brings us your tenant as a landlord. We want you to know that's so in this case, we're keeping $500 of that $800 and giving $300 away as a referral fee. Down here, we charge nothing on renewals. Other companies may have a fee for renewals. We don't charge anything. Advertising. If we wanted to pass on some advertising expenses to the owner, this is where we would do it. We're not charging anything on advertising. Interest on unpaid sums, we charge 12%. Hopefully everything's paid. It shouldn't be a problem. Extraordinary services, we charge $75 for services outside our normal purview. I don't think we've ever charged it. Normally we take care of everything related to this, but if we were to have to go to an HOA compliance hearing or something of that nature, we could charge you the $75 an hour necessary to do it. I know in the past we have gone to these and not charged. I think it might depend upon the circumstances. So to date, I have not charged any of my landlords this fee, but if I felt something was outside of our normal purview, I might impose this upon them. Collection fees, the owner has a right to enlist the services of a collection company, and then they would pay that. The management agreement does not provide for us to do that for them. Trust accounts. We have trust accounts set up for our property management. Our broker has them established. We actually have 2 separate accounts, one for the normal activity throughout the course of collecting rent and paying bills, and then another one specific to the security deposits. The initial deposit and reserve, we ask our landlords, in this case, we're asking them to keep $500 in reserve for any such urgent needs for the property. We can automatically go ahead and get those monies and pay the vendors as necessary with that $500. This instructs us to make sure we do keep a separate trust account for security deposits. This gives me authority as the broker, as your property manager, to collect rents and charges and receive them on your behalf, and then be deposited in the trust account maintained by us. If there are any special charges, we can collect them from the tenants. And also maintaining that separate security deposit trust account. In that account, the money sits there. That's actually the tenant's money. It's deemed to be the tenant's money, but we sit on it until such time the tenant leaves and we determine that the property's in good shape and nothing needs to be deducted from it. Disbursement of rents, we are authorized to pay for any and all expenses out of that trust account. If as an owner, you notify us that there's such payments or increases in things, and you let us know about these things in advance, and you want us to pay those bills, that's fine, but we may increase your reserve. As a rule, we're happy to take care of your HOA fees and your taxes if that's what you want us to do. Most of our landlords like to do that themselves, but we're happy to do that for you. We don't pay mortgages, though. We don't want to be involved in that particular part. Net proceeds, within that time frame, once we've collected all the monies and paid all the bills, we need to distribute you any and all funds above and beyond that reserve. So that's what this says. We have to distribute that to you every single month. We're not required to advance funds. As a matter of fact, they insist we don't. We're not really supposed to what they call commingle funds, or we're not supposed to be commingling funds. So we're not really allowed to use our own funds to support your property. And that's actually a violation of Nevada law. We are required to supply to the IRS a 1099 that shows your income. Your expenses can be deducted from that, of course. And we will furnish that for you at the end of the year, along with any number of reports throughout the year. Now, we use a portal where you can, as a landlord, you can access any number of financial reports 24/7 at any time. If you happen to be a foreign investor, if you're a non-resident alien, there are special IRS considerations, including withhold of a certain amount of revenue that has to be set aside for the IRS on your behalf. That's what FERPTA is. Multiple listing, you know that we're going to be using our multiple list access to market your property and cooperate with other agents in the course of doing so. You're giving us the authority to negotiate, prepare the leases, including renewals, extensions. We have that authority for you. You're also giving us the authority to enforce the elements of the lease and sign for any such services we deem necessary to enforce that lease. And then you would be responsible for any costs associated. If there's attorney fees necessary, court costs necessary, you would be responsible for that. We would always consult you before going beyond the normal purview. I've never had to do this, but if it came up, we would be able to do that for you on your behalf. We shall review the property periodically. We actually do, as a company, we send a professional home inspector into the home at the midterm of that first lease period to make sure that the home is, first of all, being well cared for by the tenant, and subsequently to make sure it's safe, make sure that everything's working properly and there's no safety issues. We have discovered in the course of doing this that there have been several water leaks that we were able to get curtailed before they did significant damage, and it saved our landlord a lot of money. This allows us to put a lockbox on the property. We use these electronic lockboxes provided by the board. Actually, not provided. We pay for them. We buy them from the board. And then we can put that on your home. And then down here, you're basically authorizing us to issue a one-day code for that box to vendors as necessary. And sometimes we use a mechanical box, too, if we find that that's more useful. But I'll address that later. These opt-outs are basically for marketing the property. If you didn't want us to allow for any commentary on the internet or automatic estimation of values, you could opt out of those things. I wouldn't encourage that. Let us market the home fully on the internet and use all possible outlets. Here, what this says is that in the course of managing your property, should a repair become necessary, if it's under $500, we're just going to do it. You're going to see the receipts, and it's going to come out of your proceeds. If it's over $500, we will get your permission. Unless it's an emergency. If it's an urgent issue, and hopefully that's never happens, but if it is, we would also be authorized to get things fixed that cost more than $500. But anything under $500, we're not even really going to come to you. We're just going to get it fixed, and you'll see the receipt. We'll likely let you know that it's been done. We wouldn't want to keep you in the dark on it, but we're not obligated to get your permission to do it. That's what this is really saying. Smoke detectors, you got to make sure that the house is safe and has smoke detectors in it. But then once the tenant occupies it, they're responsible to maintain those smoke detectors. The utilities. This is an interesting section. Here in Southern Nevada, trash and sewer and HOAs are all very much lienable against the property. So we make those owners' expenses. They're also not consumption-based. So the amount of trash or sewer you use, the HOA, there's no change in that rate based on use. Now, the other ones, electric, water, gas, and cable and internet, all that, those are based on use, and those are the responsibility of the tenant. Excuse me. Moving down, pool contractors. As a property manager, I want you to have, if you have a pool on the property, I want us to use either your or our pool contractor to maintain it. I prefer ours, but I will use yours as long as they're licensed and bonded. We'll use yours, but we want that to be maintained and in place. We don't want the tenant responsible for this because far too often the tenants don't take that responsibility seriously, and I don't want to have to worry about recouping or fixing a pool that's been not maintained properly. Same thing happens in landscaping. If the tenant's not maintaining landscaping and there's fines and plants are dying, it's not nearly as good as if we maintain the existing landscaping service and the owner provides that. Insurance. You are obligated to maintain your insurance. You want to make sure you change your policy. If you have a homeowner's policy on it, you want to change it to a landlord policy. Different levels of responsibility or coverage, I should say, with regard to liability versus personal property, because you're not going to have any personal property left in the home, but you are going to have additional liability. So you want to change your policy. You also have to name us as additionally insured. That's very important. And this is an obligation. This is a requirement. And our broker is a stickler for this. I want to make sure you understand that when we constantly talking with your insurance company, it's to make sure that you still have coverage. And that's why you're naming us as additionally insured. So we would be notified if that coverage lapsed. This also gives us the right to, if your coverage lapses and you don't renew it, we have the right to actually buy insurance for you. Again, I've never done this, don't intend to do it, but we could based on this agreement. You're going to hold us harmless for any loss or investigation of suits. We don't assume any liability for damages. We can't be responsible for the actions of the tenant or for the landlord, but we are going to hold them accountable for that. You would be responsible for any cost of litigation if we had to get involved in a lawsuit. Representations. This basically says when you're signing this document, you're saying, yeah, I own this property. This is my home. But also, you would have to let us know if you were ever in danger of foreclosure. If anybody was going to try and take the property from you, you'd have to let us know once you got any notices to that effect. That's important for us to be aware of. Hopefully it never happens, and if it does, just make sure you keep us up to speed on that. The tenant would still have responsibilities and would have to maintain those responsibilities, including the paying of the rent, but we need to know that this happens. If there's notices served at the property and the tenant finds out before we do, it doesn't look very good for either one of us. Multiple listing service is not a party to the agreement. If you're a member of a common interest community, an HOA, which many of you are, they might restrict the leasing of the property. Make sure that your HOA allows you to lease your home within their CC&Rs, and you are responsible to make sure of that. We can check for you, but ultimately you're responsible for that. This agreement can be terminated before expiration with written notice with 30 days at any time. If that happens before the end of the term of the agreement, there could be fees involved of up to $250. You are still responsible for any payments or any monies due upon terminating the agreement. A leasing fee survives if, in fact, you were able to procure a tenant out of one of the ones we had already shown the property to. We would still be entitled to our leasing fee. The indemnification survives the agreement. In other words, when this agreement's over, all these indemnifications would still be in place. Rights are cumulative. You would agree to mediate before a lawsuit. You're not relinquishing your right to sue, but you would agree to mediate first. All of these headings are just abbreviations. They're not meant to be anything other than that. Any waivers or modifications would have to be in writing and agreed to by both parties. You can't assign or subcontract this thing. We can't do that either without, again, written notices. And all notices need to be writing between the two parties based on what we put on page 1. If any part of this contract was deemed invalid, it would not invalidate the whole thing. Publicity. Basically, neither one of us is going to share any of the details of this with the public. It's not their business, unless it was required by law, of course. And law supersedes the agreement. Of course, we would defer to Nevada law. What's written here is what counts. What we're saying by way of explanation, including in this video, does not count. What's in writing is what counts. By signing this agreement, you're agreeing to it. And then here we go. Down here, we have some additional terms that we put in our agreement. And what we say to you is once you have 3 or more properties, we actually drop your rate to 8%. You understand that if the tenant were to vacate and leave a balance, that we would not be the collection agency, but we would certainly support your efforts and provide whatever materials necessary to help pursue those monies owed. Again, we reiterate here that the $300 referral commission is part of the $800, not in addition to it. And then under certain circumstances, we might place a mechanical lockbox on the property in addition to or instead of the electronic lockbox. Down here, some signatures. And then here's that exhibit. This talks about the specific nature of that property that we're signing up for now. Now, we could add an additional exhibit. We could add a B, a C, a D, or a 1, or 2, or 3, and add additional properties to your agreement if you wanted us to. We would just simply have to have the exhibit, and we'd all sign off on it. And this gives the details of this specific property, $2,000 a month, a minimum of a year. You would accept pets with a $500 deposit. There's no smoking in the home. You're not wanting Section 8 tenants in there. Here's the mailbox number of the unit, the gate code, the parking space number, and the alarm code. Here's your insurance company's information, and you're saying, yes, you've marked us as additionally insured. Here's a home warranty company that you have service through. Here's their policy number and their phone number. We would employ the services of your warranty company before we called the vendors directly to take advantage of that warranty for you. And then finally, here's the HOA information. And then here's some of the inventory of appliances that you have in the property right here. Here's another signature and a date. And that, in fact, is our property management agreement. I know it's a lot. I hope by my explanation was helpful. And certainly, should you have any questions, you can give me a ring. Thanks for paying attention. I hope you found this video helpful. Please feel free to review our other videos at www.lvrrealestateradio.com. And once again, thank you for taking the time to learn about this document. And if you have any questions, just call or text me at 702-203-1165.